Hi, everyone. I'm Lauren Conlin from Los Angeles Magazine. Don't mind me, I'm just freezing over here. I just returned home from Luigi Mangione's very pivotal federal hearing, and I wanted to jump on a live stream to sort of talk about it, go over the judge, her filing and her decision on this, and also just go through the original indictment. But I just realized I did not tweet this out anywhere. So maybe I should quickly do that. Just give me 1 minute. 1 minute, 1 minute. Here we go. Okay. Now now I'll share it. I'm so I guess last minute unprepared. Here I'll say live now. All right. Tweeting this out, and then we'll go over the decision, both of the decisions by the judge regarding the counts 3 and 4 with the death penalty, and also the backpack, which I saw that coming. I could have told everybody that she would allow the backpack in. Okay, let's post this, and then we'll get to it. And I'm going to see if I can, I'll contact an attorney halfway through to see, or I'll see if Garagos is around to weigh in on any of this, because it is pretty crazy. I mean, I will say this, the count 3 against Luigi, I'm not going to say the actual word because I don't want to get banned from YouTube, but that's the only red rum count that he had. It was red rum through the use of a firearm. And yeah, now that is gone. So, all right, just tweeted this out. All right, let's first, I'm going to pull up the original indictment here. All right, which now, they've got to get this updated. Okay. Let me know if you guys can hear me okay as well. Just make sure I'm not shouting. Just say it in the comments if I'm speaking too loud. Okay, so this is the original indictment here. Now count 1 and count 2, these are the charges that are sticking. Let me go down to count 3 and count 4, which we know now the judge just dismissed these. She did say, however, the government has until February 27th if they would like to appeal this. And look, if you ask me, I would say that the AUSA is handling the case. Those guys personally, they didn't seem like they were eager to appeal. I mean, obviously they just kind of found out around the same time that we did what the decision was by the judge, but they kind of were like, at the end, they kind of were like, yeah, we are fully prepared to go to trial. There is a very large federal interest to get this case moving, so they seemed like they were okay with the dates, with everything. But I think the ultimate decision is going to be up to Pam Bondi. And I feel like if it's up to Pam Bondi, she's definitely going to want to appeal. And look, sometimes the government just kind of goes through the motions with the appeal just for optics. So yeah, we'll see what happens there. But yes, these are the counts, the counts that were dismissed today, counts 3 and 4. And count 3, the red rum through the use of a firearm, that is really what carried or made this case death penalty eligible. So this count 3 says on or about December 4th in SDNY of New York and elsewhere, Luigi Nicholas Mangione, the defendant, during and in relation to crimes of violence for which he may be prosecuted in a court of the U.S., namely the stalking offenses charged in counts 1 and 2 of this complaint, knowingly used and carried a firearm, and in furtherance of such crimes, possessed a firearm, and in the course of that crime, caused the death of a person through the use of a firearm, which killing is red rum as defined in Title 18 XYZ. It says he shot and killed Brian Thompson in the vicinity of West 54th Street and 6th Avenue in Manhattan. Okay, so the reason that the judge decided to dismiss these counts 3 and 4, and it sort of cites that right in the paragraph. She basically said that counts 3 and 4 show as a crime of violence, and that is essentially not what this is, and it can't, they don't legally qualify as crimes of violence, which is interesting. She said that the reckless conduct is there, but it's insufficient to qualify as violent force. And she said, even though death is an element, it doesn't add required intent or force. And I think this goes along with the fact that I guess you'd have to prove with part of this interstate stalking and a crime of violence that Brian Thompson feared for his life. That would be an element to prove. And I think that is tough to prove. Although, again, I'm still trying to comprehend all of this because it is super complicated seeming. But then the second count for the firearms offense, it has to do with the silencer, I believe. It is. So it just basically says that the defendant, Luigi Nicholas Mangione, during and in relation to crimes of violence for where he may be prosecuted in a court of the U.S., namely the stalking offenses charged in counts 1 and 2 of this complaint, knowingly used and carried a firearm, and in furtherance of such crimes, possessed a firearm which was brandished and discharged, and which was equipped with a firearm silencer and firearm muffler. So that was also dropped. So that was dropped as well. Again, she could not sort of connect this to being sufficient enough to carry the crime of violence. So going back to charges 1 and 2 that are sticking, and I think count 2 is the big one here, because it's resulting in death, or I believe, let me see if, yes, count 1 is resulting in death too, or death as well, I should say. And so those two counts do carry a life sentence as well. So, and I've reminded, people multiple times. Let's see. Sorry, I'm just looking at this comment. Brian didn't have any bodyguard that morning, and he was in the biggest city in the world. Yeah, I mean, agreed. I don't think that he had any fear for his life. I don't think he had any fear of Luigi Mangione. I don't think he knew who he was at all. So yeah, I get that when it comes to the interstate stalking. But I mean, I did see, and I was just researching, federal red room charges are really tough to come by, which is why I think that these counts 1 and 2 with the, stalking resulting in death, I think that's sort of, what they're going for here in terms of red room, just because, again, there's not really, there's not a lot of cases that you see with just like standalone murder charges or, So let's go to count 1. So Luigi Nicholas Mangione, the defendant, traveled in interstate commerce with the intent to kill, injure, harass, intimidate, and place under surveillance with intent to kill, injure, harass, and intimidate another person, and in of course of, and as a result of, such travel engaged in conduct and that place, that person, in reasonable fear of the death of and more serious bodily injury to that person, and in the course of engaging in such conduct, caused the death of that person, to wit, Mangione traveled from Georgia to New York for the purpose of stalking and killing Brian Thompson. While in New York, Mangione stalked and then shot and killed Brian Thompson in the vicinity, yada, yada. So that's count 1. And then this is count 2, stalking with the use of interstate facilities. So from at least in or about November 24th, 2024, actually, I'll skip that part. You guys have heard that before. The defendant, Luigi Nicholas Mangione, with the intent to kill, injure, harass, intimidate, and place under surveillance with the intent to kill, injure, harass, and intimidate another person, used an electronic communication service and electronic communication system of interstate commerce and a facility of interstate or foreign commerce to engage in a course of conduct that placed the person in reasonable fear of death and serious bodily injury to that person, and in the course of engaging in such conduct, cause that person to wit, or cause the death of that person to wit, Mangione used a cell phone, interstate wires, interstate highways, and the internet to plan and carry out the stalking, shooting, and killing of Brian Thompson in the vicinity of blah, blah, blah. So I think right here, for both of these these counts, the big sentence is, he engaged in a course of conduct that placed that person in reasonable fear of the death of and serious bodily injury to that person, and in the course of engaging in such conduct caused the death of that person. So I don't think that all three of these elements have to be there. The person had to be in reasonable fear of death, because again, Brian Thompson didn't really know that Luigi Mangione existed. But I think that because of this charge of stalking, it caused serious bodily injury to that person. And in the course of this conduct that he engaged in, allegedly, it caused the death of that person. So I think with that, that's why those charges will stick. So let's see. Let me see. I don't know this person. I'm a terrorist, another stupid effing woman. I don't know shit. I'm so confused. I'm reading from an indictment. But thanks so much for being here. Let's see. I can see the defense using the threats Brian had received before. In my opinion, Luigi didn't send any of them. You know, it's interesting. Like that hasn't come up in any of the hearings. And it definitely hasn't really come up in any discovery that I've seen. So let's see. Okay, let's go to the judge, her actual decision from today, which is okay. Granted. All right, let's go to the counts 3 and 4 that we're talking about, and then we'll get to the backpack. Oh, let's see. Okay. Here it is, the dismissal. I'll share with you guys right now. Sorry, I'm just downloading this to make it, actually, you know what? Let me just I'll share my screen again. All right. So this is the, let's see. Wait, I know, right? I'm so confused. I'm literally reading from court docs. Yeah, so stalking could be a life sentence for him. And again, there's no parole in federal prison. Life is life. Although depending on what your sentence is, a lot of defendants, they only serve, I think it's like 85% of their sentence because of time served, good behavior, whatever. Okay, so basically let me pull this up a little higher for myself. So she discusses all of the charges that we just sort of went over. And she said, this case, or for the reasons set forth below, the case will proceed to trial on counts 1 and 2, which charge the defendant with causing Brian Thompson's death under 2 federal stalking laws. The potential maximum punishment for each of those offenses is life in prison without parole. Count 3 is a capital eligible offense on which the government filed a notice of intent to seek the death penalty. The chief practical effect of the legal infirmities of count 3 and 4 and this court's decision that they must be dismissed is solely to foreclose the death penalty as an available punishment to be considered by the jury that will otherwise determine at trial whether to convict the defendant for causing Brian Thompson's death. So the question before the court, whether under the relevant statutes and the Supreme Court precedent, the crimes charged in counts 1 and 2 are, quote, crimes of violence. And this is, I think, this is the theme of it all, the crimes of violence. So she says the court would be remiss to not note at the outset the apparent absurdity of the inquiry. So she is admitting, we know that this is kind of crazy because somebody died. And again, it says the defendant is charged with selecting a stranger to be killed based on his employment, carefully planning the killing, including identifying where and when the selected victim would be most vulnerable, traveling across multiple states to carry it out, and then gunning the victim down on a public street using a handgun equipped with a silencer, no one could seriously question that this is violent criminal conduct. Let me go to the, okay. Yeah, so I think, oh, sorry, I'll remove that comment. Okay. So she's not denying that this does seem slightly absurd in her words. And those are the judge's words. She says, it will be remiss not to mention the absurdity of this all. She mentions the silencer. No one could seriously question that this is violent criminal conduct. And yet, over the course of the last 2 decades or so, the Supreme Court has embarked upon a legal journey explained herein that now requires lower courts to engage in an analysis totally divorced from the conduct at issue and centered on the hypothetically least serious conduct that the charged crime could possibly cover. So she said this is typically the shorthanded categorical approach. So whatever the merits of that approach in context that require the assessment of past state criminal convictions, but she cites the removal criteria in Immigration and Nationality Act, or the sentencing enhancements in the Armed Career Criminal Act. I don't know that. It has proven a poor fit where the defendant's alleged conduct is encompassed with the indictment, and full fact finding, whether by a jury or by the court, can occur with procedural protections for the defendant. So it's produced questionable results that defy common sense. That's interesting. So then she's citing things that, arson is not, quote, a crime of violence under Section 924C. And then she says kidnapping is not a crime of violence. And so I think she's referencing these cases saying, yes, this does seem questionable. It does seem to defy the, common sense here that we would think, yes, allegedly shooting someone with a gun is the crime of violence. But I think she's going to tie it all together with the stalking charges. Let me see what else we have here. No new comments. Let me see. Brian's security dropped the ball. If he had security at all time and just didn't have security at that time when he was red rummed. Yeah, I don't know. I'm not actually sure if he walked around with security at all times. If he did, it is interesting that he didn't that morning. I'm not sure. Okay, so she goes on, regardless of its own views, a district court is duty bound to follow bindings, Supreme Court precedents. The analysis contained in the balance of this opinion. I mean, this is 39 pages, so I'm not going to go through all of this. Hang on. In this case, count 3 is charged under one of the few murder statutes available under federal law. So that's what I mentioned before. There are very few red rum statutes available under federal law, like there would be with state. State, you've got first degree, second degree, manslaughter. I mean, it goes on. Not that easy federally. She goes on to say that the statute requires the government to prove beyond a reasonable doubt that the charged red rum was committed during and in relation to a different federal crime, and that different federal crime must be, quote, a crime of violence. So, quote, a crime of violence is defined under federal law as a crime that, quote, has an element, the use, attempted use, or threatened use of physical force against the person or property of another. Here, the specifically alleged predicate, quote, crimes of violence are the stalking crimes in counts 1 or counts 2. So what is interesting here is almost like, well, wait, did the government muck this up with their initial charges? I mean, it's interesting to think about that. If they had charged him differently, or if they had added these charges to a different predicate besides, the interstate stalking, would there be another situation? I don't know the answer to that, but I'm sure that it's possible. So yeah, here specifically the alleged predicate crimes of violence are the stalking crimes of 1 and 2. So in this motion to dismiss counts 3 and 4, the defendant argues that the question of whether the stalking crimes in counts 1 and counts 2 are, quote, crimes of violence as a matter of law must be analyzed using the categorical approach. And she said that section 2261A is not divisible into separate criminal units. And accordingly, the modified categorical approach does not apply, even if the quote modified categorical approach did apply. Neither of these sections requires the government to prove as an element the use, attempted use, or threatened use of physical force. Because the stalking statutes encompass threats to self-harm, so long as the perpetrator is a family member or intimate partner of the stalking victim, they do not necessarily require using force against the person of another as required by the definition of a crime of violence. So in response, the government agrees that for counts 3 and 4 to stand, counts 1 and 2, excuse me, must meet the statutory definition of crimes of violence, and agrees that the categorical approach to this inquiry is mandated by the Supreme Court precedent. So I'm skipping through some of these because it just has more categorical approach verbiage and case law. Let me see. So the both of these crimes, and they're talking about 1 and 2, require the government to prove beyond a reasonable doubt that a defendant used, attempted to use, or threatened to use physical force against the person of another. And to support that argument, the court should read a mens rea of at least knowledge into the key element of the statute, and the statute cannot be read into include self-harm. So that's kind of interesting. It's saying that, you know, they have to have threatened to use physical force against the person of another. And yeah, I guess Luigi, you know, he didn't do that. He did not, or that, you know, he didn't threaten physical force. Allegedly, he just kind of, you know, stalked and went out and did what he did. Okay. So each of these arguments is analyzed at length below, but in some, the court finds that the stalking statute is divisible under 4 distinct crimes. So we've got that accordingly, the modified categorical approach must be used, that neither of the charged stalking crimes necessarily requires the government to prove use of force, as the Supreme Court has defined it in large part because the only element that could potentially satisfy that standard can be committed recklessly, which does not meet the standard. The penalty element of death resulting does not change the analysis, and this is counts 1 and 2, stalking resulting in death, does not change the analysis because it likewise does not require the necessary mens rea. And finally, the alternative, the pertinent element, can be satisfied through threats of self-harm, and thus requirement that the use of physical force be against the person of another is not met. For all of these reasons, the stalking offenses charged in counts 1 and 2, quote, are not crimes of violence as a matter of law, and counts 3 and 4 must be dismissed. So she goes on with the discussion. She talks about what is a crime of violence, which I think is actually kind of interesting. Let me see. I don't know what everyone's talking about with Trump pardoning him. I don't know where that came from. That has never been discussed at all. Let's see. Okay. Let me go. I actually do want to read this really quickly because I want to understand it myself. Counts 3 and 4 are both charged under section 924 of the Federal Criminal Code, which sets forth various laws that criminalize the use of firearms in connection with another federal crime that is a crime of violence. Okay, so that is the whole thing here. Again, these counts only stick in connection with another federal crime, which has to be a crime of violence. And resulting in death doesn't mean it's necessarily a crime of violence, although the judge points out, what was the word she used? The absurdity, basically how absurd that sounds when someone is dead. She says, yeah, count 4 is charged under section 924, which criminalizes the use of carrying or possessing a firearm during and in relation to any federal crimes of violence, and contains escalating penalties if the firearm is brandished or discharged. Count 3 is charged under section 924, which criminalizes causing the death of a person through the use of a firearm in the course of violating section 924C, and contains the escalating penalties if the death or if the resulting death would constitute red rum under federal law, in which the case penalty can include any punishment up to life imprisonment or death. In other words, both counts 3 and 4 depend by statute on the commission of the underlying crime of violence. Yeah, we know that. Crime of violence, the way it's defined, it's an offense that is a felony and has the element of use, attempted use, or threatened use of physical force against the person or property of another. I think that is the most important thing here to keep in mind, as I'm going to just screenshot this for later. So the crime of violence is defined as it must have the element attempted use or of use or threatened use of physical force against the person or property of another. And I think that's the biggest thing here. There was no threats. There was no threats of violence. There was no threats of physical force. Whatever happened, it happened allegedly just that morning, even though, again, the interstate stalking charge is sticking. So yes. I'm trying to figure this out. Okay. I'm just looking to see so now I'm looking at my notes from the actual hearing. I'll just make this a little bit smaller. You know what? If you guys are interested, let me actually play this. The lawyers spoke outside of court this morning. So I will play that really quickly. Their reaction. And they also kind of discuss what happened at the MDC yesterday with the Minnesota man who was arrested. Okay, let's get this up. Oops, that's too big. All right.
Good morning, good afternoon, everyone. Just wanted to thank the court for this incredible decision. I want to thank this amazing legal team that we have here. Really wonderful, all of them. And thank all the people who come out, stand here in the polls, and the people who can't come here, all the supporters. We get your letters, we get your emails, and we really appreciate all the support. So thank you all. Stay warm.
Karen, what was Mr. Mangione's reaction when he learned the death penalty was off the table?
We're all very relieved.
What was their reaction last night to the attempted breaking Luigi out of prison?
Honestly, we have a big filing that we filed in state court last night, and we were anticipating today. So I don't know anything about that. I heard about it and understand that there was not even any mention of Mr. Mangione. So I don't know that it's even related. So I really don't know anything about that individual.
Karen, how much of a setback is it that the judge is going to allow the contents of the backpack at trial?
Oh, we didn't get to that, so I should.
We're prepared and have been prepared to fight this case, and we look forward to fighting this case. So
do you have any comment about the state trial happening at the same time or possibly earlier than the federal?
we're going to work that out with everybody. So, but we anticipate fighting these charges. So, thank you. Thanks, everyone.
Great job. It's not for you to hang out in. It's people to walk.
Okay, so that's what she said outside of court. And by the way, as far as the Minnesota guy that allegedly tried to spring Luigi from the MDC, she's correct. Luigi's name was not mentioned in the complaint. However, a law enforcement source did explain to press and the media what happened, and that Luigi's name was used when he kind of entered in and said the inmate that he was he said he had a court order signed by a judge to release this inmate. And so the law enforcement source did relay that to press and say, yeah, it was Luigi. However, again, Luigi's name was not mentioned in the complaint. And I'm sure that is also by design, because I think that would infringe on Luigi's right maybe to a fair trial. I mean, that's just my thought. And I also feel like that's also smart of the defense to downplay that, just to be like, we have nothing to do with this. We really have no idea what, what this guy was thinking. Just leave us out of it. So yeah, let me go to the filing about the backpack. Here it is, main document. Let's see. Okay. So look, I don't think anybody is surprised that the backpack is allowed in. I mean, I wasn't surprised. And I think it was maybe an easier decision for her. She seems to obviously give and take a little bit. But here, let me share this tab instead. This is a pretty long filing, so I'm not really gonna go over the whole thing here, but essentially she just says, for the reasons that follow, the motion is denied to suppress the backpack and all items contained therein. So she said, the relevant facts are undisputed, goes through the McDonald's situation, whatever, talks about the two officers of the Altoona Police Department initially responding. When it became clear that the officers believed the defendant likely was the person being sought in connection with the Thompson Red Rum and was going to be taken into custody, one of the Altoona officers did a cursory search of the interior backpack for anything that could hurt or injure her during the transport to the police station. In the course of that initial search, the officer found a loaded gun magazine. The backpack was then transported to the police station in one car, while the defendant was placed under arrest and transported in another car. Then they go through more of the search that happened. Okay, then we have where the warrant was submitted, and this warrant here, and again, this, guys, keep in mind, this is the federal case. This is not the state case, so it's a little bit different. So the backpack and its contents were eventually transported to Manhattan, where Brian Thompson was killed, and where local and federal authorities started to investigate the Red Rum. But also keep in mind, the federal authorities did not start investigating, or federal prosecutors did not get involved until 2 weeks after. And here we go. On December 16th, 2024, the U.S. Attorney's Office for the SDNY applied for a search warrant to search the entirety of the backpack and its contents, including any written materials obtained or contained therein. The warrant application was based on a sworn affidavit submitted by the FBI Special Agent Gary Cobb and was approved by a magistrate judge in this district. So then on December 31st, 2025, the court issued an order asking the parties to submit a letter indicating whether either party believed an evidentiary hearing was necessary to aid in this court's evaluation. And actually, originally, the judge said no, like, we're not going to have an evidentiary hearing. And then she said, actually, you know what, let's just have one. And it was very painless. It was only an hour long. We only heard from one Altoona police officer, and he wasn't even there that day. And it was just to go over, their policies there. I think he was a lieutenant, if I'm remembering correctly, but it's different because, again, the federal government didn't really get involved in this case until 2 weeks after the state did, or I should say the NYPD did, and obviously Pennsylvania. So, there you have it. You saw the way that the warrant or the backpack was contained, and then you saw that the federal government did get a warrant to, handle all of these items, review all these items, and it was granted. So I kind of felt like, again, she wasn't going to suppress anything federally. But when it comes to the state case, I feel like, Judge Caro is not going to make a decision until May, which is crazy. But I think he could go either way because both sides made really, really relevant arguments here. And I really do think it's just going to, when I say it will depend on the judge, obviously it's going to depend on the judge, but I just mean it's going to depend on the way he interprets some of the case law. And it's crazy. It was very, very complicated. So let me go back to this. Okay, so court held a suppression hearing. Yeah, we know. Talks about Chief Snyder, who was there, didn't participate in any way in Mangione's arrest. He testified working about his experience as yes, and the training. Okay. So the defendant argues that the backpack search that occurred at the McDonald's was not a valid search incident to arrest because the bag was no longer accessible to the defendant at the time it was searched. So that is that's also the state argument. Was the backpack in grabbable distance from Luigi? And, maybe I blocked a lot of it out because it was just such a long 3 weeks, but the backpack seemed to move a lot. The officers they took it at one point, they moved it away from him, they put it behind him on a table or something like that. And so I think that it was argued frequently that the backpack was moved. He couldn't reach it. So, they should have never searched it. That was a really big part of that argument. So, let me go back here. So yeah, they're saying it was no longer accessible to the defendant at the time it was searched, and that the purported safety search before transport was either a ruse or exceeded the permissible bounds of a pre-transport safety search. And this goes back to the defense arguing that, look, you guys only searched that backpack because you knew he was wanted for this red rum in New York. If this was just a regular old arrest, where he was arrested in Pennsylvania for like the falsifying an ID, they're like, if this was a regular old arrest, like that would have never happened. You would have never searched it. And they're arguing like, yes, we would have. We would absolutely search the backpack of somebody who was just arrested. And that's part of our protocol. So big part of the argument there. The defendant also argues the inventory search of the backpack done at the police station was not valid because the purported inventory search was in fact a ruse for an evidentiary search, exceeded the permissible scope of an inventory search by, for example, reading the contents of certain writings covered from the backpack, and otherwise it did not follow established procedures. So finally, the defendant argues that the inevitable discovery exception should not apply because the exception would have to be based on a permissible inventory search, and the officers of the Altoona Police Department did not conduct a proper inventory search. The government argues in turn that the backpack and its contents are admissible under several exceptions to the warrant requirement, including the search incident to arrest, pre-transport safety search, and an inventory search at the police station, and in the alternative, inevitable discovery arising from a combination of an inventory search and the December 16th federal search warrant, which did not rely on any information gleaned outside of these permissible circumstances or activities. I'm sorry. So yes, it's clear. The judge obviously ruled with government here and basically said, nope, it was lawfully searched. And not only that, the federal government waited, they got their search warrant. One has nothing to do with the other. Yeah, this is another 43 pages and it has some exhibits as well. Yeah, here are the exhibits. These are just this is, the black backpack identified. This is the application for a warrant by the government. Yeah, this part, I don't think we really need to go over this part. Let's see. I am getting a call. 1 second. Let me see. Hey, how are you? I'm good. I'm actually, I'm doing a live stream, but you're not on speaker or anything. I just am picking this call up. So yeah. But sorry, you got my text. Yeah, that would be great. And anything you want to add, that would be awesome just for the story I'm about to file. From Luigi this morning. Just thoughts. Yeah. All of that. Cool. Yeah, I can, okay. So do you want me just to do that? Okay, okay. Okay. Mm-hmm. Yeah. Okay. Got it. Hmm. Okay. Yep. Okay. I can work with this. This is actually really helpful.
So then what happened is the argument all along has been, what the two sides have been arguing about is whether stalking is by definition a crime of violence.
Yep.
And the judge decided today that by definition it is not a crime of violence. It's not fully defined by that. And that's
Hmm.
in the last hearing, you know, I think got kind of arcane for a lot of people. They didn't really understand what the arguments were, but the defense was arguing how there are instances of stalking that are not really violent.
Right. That I do remember that in the government's, yeah. Or sorry, the defense's argument.
And that's why that sometimes I don't understand what you're talking about. You're trying to show that stalking is not always violent, and therefore is not a, by definition, crime of violence in all instances. And so
Okay.
there's all this argument about divisibility, like to say that I don't think it's, but
Yeah.
you find an instance where it's not a crime of violence. Does that mean then that it's by definition not a crime of violence? There are it's issues are not divisible. If it is not a crime of violence in a single instance, that means it's by definition can't be a crime of violence across the board. And
Okay.
they won that.
Yeah.
The judge said, okay, not a crime of violence by definition, therefore it's not a federal murder charge, and therefore charges 3 and 4 are out. Therefore, we don't have the death penalty charges.
Okay. I'm going to put this together and then I'll text you for approval. Okay. Okay. You're the best. Thank you. Okay. Bye. Okay. That was somebody I was getting a quote from for my story after, but actually what they said was super helpful. And it kind of echoed what I had said earlier. So he basically said the federal system really, again, doesn't issue these standalone murder charges. He said usually the murder charges are part of a bigger picture here of, let's say, a racketeering case. So, they can charge you with murder under certain predicates of the Racketeering Act, for example. That makes sense. And so he said he kind of called it a federal hook, if you will. You need a federal hook. And so in this case, the government's hook was these stalking charges, but it just goes back to them not being admissible as a crime of violence because the defendant did not fear for his life, there was no threats to his life, etc. And I think during one of the earlier hearings, the defense, or yeah, they were arguing like there can be basically stalking crimes that are nonviolent, where violence wasn't intended, but it happened. I mean, there were all these hypotheticals during that hearing, I remember. So that was pretty crazy. So let me see what else he just said. Yeah, pretty much he said what we had already discussed and what I had kind of said earlier. So that was helpful, I think, for me. But I have to file a story on what happened this morning with Luigi. So I am going to get to that, but it was helpful for me to sort of lay everything out on the table. So if you guys don't subscribe to Los Angeles Magazine videos on YouTube, you should. Please subscribe. I'll do live streams every once in a while. And I do daily podcasts every day. So you can see those right here on the channel. And I have a lot of different guests, like attorneys and people that are way smarter than me that can break down the law a lot better than I can as well. But all right, I'm going to get to work, but hopefully this clears certain things up for some of you that might have been confused as to why the only red rum charge that Luigi faced, why it's gone. But again, he still does face life in prison. So anyway, guys, thanks for watching. Thanks for being here. I'm Lauren. I will see you guys soon.